it going. Hi, everybody. Thank you so much for joining us. I'm Michelle Morris with Consolidated Planning Group. We host these webinars 2 or 3 times a week because we are really trying to educate the public and advocate for the community. And I want to thank you, first of all, everybody, and especially you, Michelle, for being here, because I feel like, a better educated community is a stronger community. And the more we present these webinars, the better information is out there. So again, thank you all for being here. Consolidated Planning Group is based just outside of Houston, Texas, but we do serve families all across the United States. So feel free to share this with anyone you know who might be served well by this information. A couple of just housekeeping items before we get started. We do record all of our webinars as we present them live. So later on today, if you have pre-registered for this webinar, or maybe you gave us your email address when you were signing in, we will send you a link to the recording. We are also going to send you a copy of the slides, along with, of course, our contact information so that you can reach out to Michelle or that Michelle or this Michelle if you have any further questions. So you'll get the slides and the recording. The other thing I want you to know is that since we're in webinar mode, we cannot see or hear the audience. Feel free to enjoy your lunch, snack, drink, whatever. Any questions or comments you have, we don't want to miss that. So feel free to put those in the chat box and we'll answer as many of your questions today as we possibly can. Again, I'm Michelle Morris with Consolidated Planning Group, financial planning firm. And today with us, we have Michele Goldberg. She is an attorney who focuses on some of these special needs topics like we do. So she is one of the experts that we trust. And that's why we have her with us today to talk about guardianship and how important it is to set things up correctly for your loved one. Michelle, do you want to go over your disclaimer for us?
Yes, please. Anything that we discuss here is not direct legal advice to anybody. We're going to be speaking in general. Both Michelle and I have, the other Michelle and I have some specifics that we'll use as examples, but I think one of the things we want to drive home is there's no yes, no answer to guardianship. When we say it's nuanced, it depends on what's appropriate for your child and your family. But this is general information. Do not accept it as legal advice. And that's it.
All right. Thank you. Very important stuff to remember. So without any further ado, I'm going to let this presentation be turned over to Michele Goldberg, the expert attorney, and she's going to be talking to us about guardianship and how it's not right for everybody. One size does not fit all. And we understand that everybody has their own specific situations and it may or may not be right for you. So today, feel free to put your questions in the chat and we'll get going.
So I'm just looking here quickly. I know the slides because we put them together together ourselves. We put them together together, but I want to just see what's on this slide. Okay. When people call me and tell me they have a special needs child and they need to look at guardianship or they don't want guardianship. I don't want guardianship. Okay, you don't have to do it. There's nothing in the law that says you have to have it. And you are your child's natural guardian by law until the 18th birthday. So it's on the 18th birthday that your child becomes independent, that becomes emancipated. And what that means legally and why the courts require that you have an attorney, just as the way of a little background is, on the 18th birthday, everybody in every state in the United States automatically becomes an adult by law. But what does that mean? Some people call it the age of consent. It means that that's the date that we get our constitutional rights. They're invoked. And so when somebody calls me, I'm thinking, what can this child handle on his or her own? Or what does he need? What will he need the parent or another family member or somebody to be able to handle for him? Among the constitutional rights, we always think of the right to vote, but there's a lot of constitutional rights. They're all important. The two biggies, I think, for the special needs community, one is the right to enter into a contract. And we do that all day, every day. We don't even think about it, especially now that we do so much online. So that's your bank account, your cell phone, your credit cards, your mortgage, your rent, your car note, your insurance policies. That's major. Medical insurance and other insurance policies. Signing medical consent in a doctor's office. These are all contractual relationships. If your child's in a program and you're signing the paperwork, that's a contractual relationship. Can your child process that information enough to understand what your child is getting and what your child is expected? A contract is always something has to go two ways. One gives and the other gets and vice versa. So can your child handle that information? And it's not only can your child handle that information, can the person, especially with doctors, will the doctor allow your child to sign medical consent? Some doctors will say, I'm sorry, she just doesn't understand. I can't accept this. I have my own, doctor's not going to say this, but the doctor is thinking, I have my own liability. This person can't process the information. I can't let her sign her own medical consent. If your child's over the age of 18, you cannot sign on his or her behalf. I know you're the parent. I know it doesn't seem fair. So you want to look at that. Some of the higher functioning kids are the ones, unfortunately, that get into trouble with online predators or other kind of scammers because they want to have friends and they can often be easily manipulated. They're vulnerable because they can't discern all of the dangers and, once again, the consequences of interacting with people that are not okay. And so you may need the guardianship for that. I have some clients recently that I met when I do a lot of public speaking, that I did public speaking 20, 25 years ago or more. And they said, I saved your card, which is a big honor. But anyway, I'm approaching 80. My son's in his 50s. What should I do? He's always lived with me. So with that client, and I have several that have been calling me recently like this, with that client, I'm saying maybe we should look at guardianship now, even though you didn't need it before, because that's the way you can make sure that your daughter or the cousin that's close with your son can step in easily into your shoes. You still have to go through the court system, but can more easily step in to make sure that your son is protected when you're not here.
Now, if somebody, I mean, typically we talk about guardianship when someone turns 18, but if it's later down the road, is it more difficult if they're a little bit older to get that guardianship, or is it just, the same procedure?
It's the same procedure. We often explain to the court, I got guardianship once for a man who was in his 60s. He had always lived in a small town right outside of Houston, but everybody in town knew them. He always lived with mother and father. Father died, then mother died. His brother, might have been younger, it doesn't matter. It was his brother, also around there, late 50s, 60s, took him in and was taking care of him. And every time they went to the doctor, because he had ongoing medical needs, especially as people age, it's not, may not be related to the disability. It's just you're getting older. You have high blood pressure, high cholesterol, whatever. And the doctors would say, "Who are you? I'm sorry, you can't, you can't sign for this." Well, my mother. You let my mother do it. Well, your mother's not here. Like, we can't let you do this. So we got guardian.
Yeah.
But that's a really important question. People ask it all the time. Or Michelle, the clients call me in a panic. I should have taken care of this before. No, now's the right time.
It's okay. It's okay.
Now's the right time. Oh, one of the biggest questions, and somebody sent in a comment a couple of days ago, and Meredith, who's also with Consolidated Planning Group, sent it to me. And the person, if you're listening, you'll know what your story, you'll recognize this, because I do want to address it. Her son's under guardianship in another state. They moved to Texas to help take care of her mother. She called for legal advice. Do I have to transfer the guardianship? She got legal advice that I thought was not appropriate. It turned out not to be appropriate, and she paid a lot of money. In my opinion, it was too much money. Those attorneys shouldn't have taken that much, from what she wrote. How do you tell if an attorney, and I'm going to get to these slides, how do you tell if an attorney knows what they're talking about? It's a little hard, because you call an attorney, you get a name, and you assume that they know about guardianship. Not all attorneys know about guardianship. Guardianship is also for the elderly. Granny's got dementia. You got to get her out of her house. She refuses. How do you get legal authority to move her into a nursing home? How do you get legal authority to sell her house to pay for the nursing home? That's guardianship for the elderly. But the special needs community is special, and there's different considerations. One thing that and it goes with this slide, which is what triggered my comments here. One thing I think always, in my opinion, an attorney should be asking for your special needs child what her medical considerations are. Because if somebody is medically frail, then we the attorneys need to get specific information and find out what exactly you mean by that. What kind of procedures is your child getting? What kind of medications is the child need to take? Have there been hospitalizations? Are these things, if you're not around, that your child could handle on his own? That's a key question, because that can determine if you need the guardianship. And if your child is medically frail, I think you need the guardianship. I think when you're interviewing attorneys to represent you in a guardianship, have that as a checklist. Did this woman, did she even ask me about the medical condition? Because that's going to be a key. All these follow-up questions. Could my child give the doctor adequate history information? Could my child advocate for himself? One of the reasons I see for special needs parents to get guardianship is to be able to advocate for their child, because sometimes the child just knows something's not right or doesn't feel comfortable at the day program or at a residential program, but he can't articulate what's wrong. And even if
Yes,
he could,
exactly.
right? Have you seen that, Michelle?
Oh, yeah, we see that all the time. We have these kiddos who may be nonverbal, or they'll say things. I had a woman the other day tell me that her child told the judge that he was working 20 hours a week, and she's like, no, he works 2 hours a week. So sometimes they just don't know, and we need to be able to be there to help them.
Exactly. And and once again, don't think I'm pushing guardianship. It may not be for your child. But if you need to advocate for your child on a regular basis, you probably will need the guardianship, because if your child's over the age of 18, maybe you won't see it at 18, but you'll see it within a few years. The day program, the job, the residential, whatever the residential arrangement is going to say, you're not the guardian. We can only talk to him directly.
Yeah, yeah, exactly.
It's very important to look down the road. Well, this goes along with the comment I made before, that I'm getting some new clients that are elderly now, and they're nervous. What's going to happen when something happens to me? My son has always lived with us, and he's in his 50s now. I often ask, have you ever sent them to some kind of respite program? There's some programs where they can go for the weekend, just get them out of the house a little bit, see if they can live somewhere else. But you need to look at this and say, who's going to make these long-term decisions? Sometimes it's a family discussion.
Yes, yes. One client told me their feelings about, the child's siblings being in charge. And they said, I feel like the best gift that I could ever give to the other siblings is to make sure that this one is taken care of, both financially and with residential help, so that the siblings don't have to take on that burden. Michele, could you talk to us a little bit about the difference between like guardianship and just having a medical power of attorney or a healthcare power of attorney?
Yes, definitely. So only since we're already talking about guardianship, I'll address that one first. Only a judge can appoint a guardian. It's a legal proceeding, and you have to go to court. And it's probate law. So if you're in a county with probate court, you'll be in probate court. Otherwise, you're in county court at law. But those are details. But it's a very serious legal proceeding, because when somebody goes under guardianship, their rights are taken from them. They're given to the guardian to protect. They're not without rights. They're not disenfranchised. You can retain the right to vote. The guardianship I did yesterday, we retained her right to vote, and she's severely disabled, physical and mental. But the doctor said she could vote, and so the judge allowed it. But when someone goes under guardianship, if you're the guardian, you will have full legal authority to continue taking care of your child, make medical decisions, residential placement, decisions, advocate, handle insurance, handle all the things that your child needs for in our daily lives. Only a judge can appoint a guardian. Only a judge can terminate a guardianship. And we can talk about that later if there's time, how you terminate a guardianship. We see that sometimes with high functioning autism as the kid gets older and doesn't need, it can be more independent, and on with mental illness. And once somebody becomes, they might need it while they're having multiple psychotic episodes, but then as they stabilize, we can terminate the guardianship. Powers of attorney are very different. And if your child is high functioning, I recommend the power of attorney. Try it. A power of attorney is an agreement between two people. In Texas, we have there's several forms that I lump together and call powers of attorney, but you would need the medical power of attorney, where your child would say, I appoint my mother and father, or my mother and or my father, or my mother and or my grandmother, or my father and my older sister, whatever the combination is, to make medical decisions on my behalf. There's the HIPAA release, which is consented disclosure of medical records. There's the statutory durable power of attorney for financial and business decisions, like talking to the insurance company, whether it's Medicaid or another insurance company. It is a legal document. The big difference is it's not binding on anyone. If you're the guardian, you have a court order. You have an order from the state that you live in, and that's binding on anyone you present it to, the doctor, the hospital, the bank, and anybody, Social Security Administration.
All those people we need to talk to on a regular basis.
Exactly. Well, Social Security can be difficult, but we already know that. Difficult to deal with sometimes, but we already know that. A power of attorney, in contrast, is very easily revoked. So how is it revoked? And I think it's going to come up on one of these slides, but let me get into it. And I had somebody that came in once. They were dead set against getting guardianship for their child, but their child had ongoing medical needs. And that was one of my questions, and had to have blood draws. I think it was something like every 6 months, so fairly often. And I said, well, and the kid wasn't 18 yet. And I think she had Down syndrome, as I recall. And I said, what happens when you go to have her blood drawn? Oh, she screams and hollers. I said, what do you do? She wasn't 18 yet. We tell her, you have to do it. You just have to sit there. We hold her hand. She gets it done. I said, well, let me tell you. And they wanted to do powers of attorney. I said, once she's 18, even if you have the power of attorney, when you're there and at the lab or in the doctor's office, they want to draw her blood. If she says no, that's a revocation of the power of attorney. It's revoked. Her saying no revokes it. That could be a problem if there's ongoing medical needs. The other problem, limitation, it's not a problem, it's a limitation with the power of attorney, is it can be declined by the third party that you present it to, the doctor, the school, the residential arrangement, the day program. I declined a power of attorney just within the past month. I'm doing guardianship for an elderly woman who has very aggressive form of dementia. Her husband also has dementia. Her 2 adult children applied to be appointed her guardians. I had to have her husband served with citation. His brother called me and said, my brother can't talk to you, but I have a power of attorney. And my clients didn't want me to talk to him. But I said, when was the power of attorney signed? It was recent. I said, I'm sorry, I cannot accept that. I will not talk to you.
Yeah. I mean, it takes 3 people in some of these cases. So one question that I see in the chat box, people are curious about supported decision making as well. So we talked a little bit about the power of attorney versus guardianship. How about that supported decision making? I think that's even less binding. Is that true?
Yes, and even if you have the supported decision making act form, even if you fill it out, you still need the HIPAA release, which is consented disclosure of medical records. So your child had to have signed a power of attorney. And you have to be 18 to sign a power of attorney, and you have to have capacity to sign a power of attorney. So the supported decision, and you have to have the FERPA if they're in school. That's the consented disclosure of educational records. The Supported Decision-Making Act, I think it's great. I think parents should have to sit with every high school student, not just special needs, because it makes you sit down and go, what do I have to make decisions about?
Mhm.
Kids that live at home, especially with if somebody's on this webinar, they're probably they're parents that are taking care of their kids. They're looking for information.
Mhm.
Just sit down. What do I make decisions about? Medical, because a 17-year-old, medical, dental, school, all that kind of stuff. But it's not legally binding on anybody. So a lot of attorneys, I sign them. They're great, but it's not legally binding. It's an agreement between you and your child. And what it says is, I appoint my parents to help me make decisions, but the decision is mine. So I know a lot of people promote it and promote it in lieu of guardianship. It's not in lieu of guardianship if your child needs a guardian. It can be declined just like the HIPAA can. And by the way, sometimes I have clients come in and their child's high functioning but borderline, and I'll say to the parent, does your child see a doctor? And a lot of them are under the care of a psychiatrist because they need meds for anxiety or OCD or behavior problems. Let's ask the doctor. If your doctor says that your daughter can sign POAs, powers of attorney, I'm good with it. I'm not a doctor. If your doctor is hesitant, saying, I'm not sure she understands the consequences, then I can't prepare them.
Tell us a little bit about the social media dangers. I'm
Oh my
interested to hear
gosh.
this story.
Oh, it's awful. And the family that was in yesterday, I keep referring to them, that their daughter is already 18. They had the blocks on social media, and when she was 18, they couldn't put the same blocks on. I don't know about all those laws with social media. Yes, listen to the story of one family who had a predator show up at their door. I've had clients that called. The kids, boy or girl, are on social media and they'll say some creep, he was in his 50s, showed up at the door. And I've had many call like this. What
Many. Wow.
Yes, because the higher functioning kids, they're on social media, they cannot discern, many can't discern danger. And there's also creeps out there. Sometimes you can't discern a scammer. The person
Yeah,
says he's
yeah.
19, but he's not. He's 56.
Hmm.
Um, yeah, it's a problem. You have to block the social media. You have to keep but the kids are wily, you know? Even the kids with limitations, they figure out how to get on another program. If you're under guardianship, you can, it will give you more bite if you have to call the police. If somebody does show up at your door and you call the police, if your child is over the age of 18 and some creepy 56-year-old shows up at the door, or older, or even younger, a creepy 30-year-old shows up at the door and you call the police. If your child is under the age of 18, the police will tell you and the district attorney's office will tell you, she is a consenting adult. He is a consenting adult. We can't do anything about it. If your child's under guardianship, they can at least file a complaint. And if they can catch the guy, say, stay away, you got to stay away. You could get a restraining order. I have some parents that their daughter's already 40. They're constantly calling me to get restraining orders, but it's hard. It's hard to get a restraining order because you have to know where the person is. You have to serve them with citation. It's very difficult, especially some of these kids are picking up homeless people, bringing them home.
Ah,
It's tough.
so yeah, when your child turns 18 and all of a sudden they're an adult, you could be uninvited to a lot of stuff that's going on in their life.
Correct. Correct. If you have the power of attorney, if your child's high functioning and you have the power of attorney, then you can present that to the school or the employer or the residential placement administrator day program. However, as I said earlier, and I gave the medical example, if it's time for the ARD and you've got your child signed a power of attorney, said you can represent them for business and financial things, and that would be the ARD. That falls under that category. It's not medical. If you get there and your child says to the school, I don't want my mother here, and the mother says, well, here's my power of attorney. Here's my power of attorney. I don't want her here. You're out. Out. That spoken word revokes it. If you're the guardian, they have to allow you there, and so does your child. That's a
So that's a big difference.
that's a
What
big
about
consideration.
signing contracts? You know, in a previous life, I was a realtor, so I do know a tiny bit about contract and contract law. And they always said that, if the person is disabled and doesn't understand the contract they're signing, then the contract is void. But this really puts teeth to that. Is that right?
Oh, yes. I've had talking about contracts. Here's one. It's come up in my office several times over the years. Child is very high functioning. You don't want to get the guardianship. I get it if you don't want the guardianship. I get it. You want to make sure your child, you want to promote your child's independence. But I've had several over the years that found a friend, or the friend found him, and they went up to the Apple store or the Verizon store, AT&T, and the friend goes in, and your child has good credit because you oversee everything. And your child signs the contract. You know how easy it is. They stick an iPad in front of you and you just scribble on it, and you've signed a contract. And they walk out, and the friend takes the brand new iPhone or iPad and walks outside of the store and takes off with that device, and your child is stuck with a contract. You can't get him out of it. If he's under guardianship, you can. You might have a fight, but you have the fight because the burden is on the creditor to extend credit to buy that device, to look into it. If that person is really able to get credit, if he's under guardianship, he can.
Ah, there you go. That's hugely helpful. Now, can you talk a little bit about, who is the guardian and what responsibilities do they have? And if you have something like co-guardians or you want to switch guardians or a
Oh,
guardian passes away, can you talk about some of those things for us?
yes, very good. Okay, I live in Texas, and guardianship law is state law. You don't go to federal court to get a guardianship. You go to a state court. I said earlier, it's probate law, so it depends on the county you live in. You've got a probate court or you have county court at law. Don't worry about those details. That's for the attorney, but I just want to bring that up because each state has um, its own laws. But in Texas, I've seen, because I've transferred in, I preface my next comment. I've transferred in a lot of guardianships from various states, not all 50, but many states. Some states will allow a parent and an adult sibling to serve as co-guardians, not in Texas. In Texas, the Texas Estates Code is very clear. Only one person can serve as guardian unless you're the parents. You can be the divorced parents and serve as guardian. And I've done that for many, but you have to get along. I've done it for many clients over a year because they do get along. They're not going to be married, but they get along, especially in taking care of their children, which is,
Right. And sometimes that's the only thing the two people will have to discuss or have in common, but they want to work together on this one thing. So,
yeah, exactly. So now what you could do is, so only one person can serve unless you're the parents, and even if you're divorced, you don't have to be married. You can have the elderly woman that I spoke of before we haven't finalized the guardianship yet. We have a court date set. One of her adult children, and the adult children are 50 years old, around 50 years old. One will be guardian of the person to make all medical and living arrangements for her and advocate for her, and the other one will be guardian of the estate to take care of things. So we have their brother and sister, but they're each a guardian of either the person or the estate. I've gotten guardianships for a parent and a step parent. I've done that. And the courts have allowed that because the step parent is raised. Sometimes the parent died, the
yeah.
biological parent died, or the biological parent is AWOL somewhere. And so the
Hmm.
court will allow it. Then what happens when the parents get older? If a parent dies suddenly, if the child, and the child could now be 50, if the child
Yeah.
is under guardianship, exactly, the guardianship stays with the child. The guardian can change, and that's called a successor guardian, and it's a very abbreviated proceeding. The big proceeding, the big flurry of work and the big expense is to establish the guardianship, because we have a lot of steps that have to be followed. It's all in the Texas Estates Code to protect the person's constitutional rights.
Mhm.
and there's many of them. Once he's under guardianship, as I said, the guardianship is permanent for life and stays with him, but the guardian can change. So if the parents have died, or some of the parents are just too old, maybe dementia set in, or I have several people who have retired and moved to a different state, but their adult child lives here and is in a great setting, a group home
Right.
or facility. And so the adult sibling takes over. They will need an attorney. They file an application to be appointed successor guardian, and it's very abbreviated. You don't have to reprove the medical need for guardianship, and there's a bunch
Good.
of other steps. They do have to, all guardians now in Texas have to register with a state agency called the Judicial Branch Certification Commission, JBCC. All in Texas, all guardians, even if it's the parents, are subject to a criminal background check. And by the way, I've
Right.
got guardianship for people that have something in their criminal history. It's usually from 20 years ago, there's a DWI, something like that. As long as it wasn't anything that was an aggravated assault or a way to harm another person. And it's so
Right.
far in the past, and you say, or so I had one that was shoplifting. You say, Your Honor, it was 20 years ago, and nothing
Yeah.
has been clean since. So we can work around it.
Yeah. But I bet if it was some kind of monetary fraud within the past 5 years or
Forget
something
it.
like that, there's no way.
Or any
So
kind of domestic violence, anything like that, totally forget it.
yeah, yeah. Now you talked about if a parent, they have successor guardians. What if there is nobody else?
Oh, yeah, and there's a lot of people like that, unfortunately. So I'm in Harris County, Texas, Houston. Harris County has a Harris County guardianship program. It's for people who are supposedly indigent and on government benefits. If you are able to leave money for your child, maybe you have a special needs trust, or hopefully you've worked with consolidated planning, you've got a good financial plan, which would include the special needs trust, then the courts there are private professional guardians, not many in this Houston. You'd think in a huge metropolitan area like Houston, there'd be a lot. There aren't many private certified guardians, but there are attorneys. And over the years, I've served as court appointed guardian for someone that didn't have any family to serve or appropriate family to serve. So the judge can appoint an attorney to serve, and a lot of attorneys do it. I don't do it anymore. That's just where I am in my practice. And then we're paid from the person's assets from the trust. We have to
Mhm.
submit our fees to the court and get court approval for the fees. And the courts keep a really, at least in Harris, all the counties around Harris, Fort Bend, Galveston, Waller, Montgomery, they keep a really tight rein on what we can charge, and we get paid for it.
So, big elephant in the room, how much does guardianship typically cost? I mean, and what if people simply can't afford it?
Yeah. So guardianship, there's a huge range of prices. We're a service profession. And I mentioned it earlier from the comment that somebody wrote in. She moved from one state to Texas and was intended to go back to her state and what these attorneys charged her. You're going to see a range of fees. I think an average, you're probably looking at a good $5,000 plus, but there's a range. It might be a little less, it might be more. That's for guardian of the person only, for a special needs child. If it's for an elderly person, see, if it's for an elderly person, expect to spend a lot more, because if it's guardianship for an elderly person that now has some form of dementia, it's usually for dementia. It could be Parkinson's related or Lewy body or whatever it is, Alzheimer's. Remember, that person has a work history. That person acquired assets, has a house, retirement benefits, usually investments, a car or more. And so those assets have to be managed, and you have to get court authority to manage them. So that's going to cost more. I'm not even going to give prices because that's an ongoing reporting requirement. But for the special needs kids, in general, you should be doing guardianship of the person only. You don't want your kid to have assets because they won't qualify for benefits.
Right,
So you're
exactly.
planning with consolidated planning. They'll tell you how to have assets for your child, but have it protected. But I'm going to say an average price is probably 4 to 6 or 7,000, something like that. And we have, because we have court costs, we have to pay for the service fee, we have to have them serve a citation. The courts now in Harris, I think most of the surrounding counties, we have to deposit into the registry of the court when we file the application for guardianship. We have to deposit in Harris County, it's $750 for the attorney ad litem fee. When you apply for guardianship, the judge has to, by law, appoint an attorney to represent your child. Why? His rights will be taken for him and he has the right to counsel. And so we have to deposit the money up front, but then it's paid, you don't have to worry about it.
So between 4 to 7,000, and it can
Probably.
vary on each side.
Yeah.
But what if, they can't afford it and they don't have someone, and then what?
Yes.
Does the child
So
just become a ward of the state, or?
no, people always worry about that. The state's not running around looking for people unless to grab up, unless something's going on. Unless, let's say somebody, and I've seen cases like this, let's say somebody, a special needs person, is in and out of the hospital and well over the age of 18, and the parents haven't gotten guardianship. The hospital, I've seen it a lot, that a doctor or somebody, a social worker, somebody in the hospital will contact the probate court and say, we have this recurrent patient who's here because of ongoing severe medical needs, or is vent dependent or feeding tube or whatever it is. And the parents won't get guardianship. Can you appoint a guardian for the person? And then the judge by law has a duty to look into it and find a guardian. But let's say you don't have money. And I had somebody call me just the other day. I had done her brother's guardianship, and then she has a special needs child. Divorce, bitter divorce, the ex doesn't help at all. And even though I offered her a really big discount because I had done her brother's guardianship and she's divorced and really struggling. I sent her a list in Harris County. We have the Houston Volunteer Lawyers Program. There are 3 law schools in Houston that have legal aid clinics, and you can apply to them. You've got to fill out the forms. You have to qualify and qualify financially. You have to show that you really can't afford it. And there's a waiting list, and you might have to wait a while, but they do a really good job. They do a good job.
Yeah,
The
that's
law
good.
schools have, all 3 law schools, they have a professor that oversees the program, and they'll have a student work it. So if somebody called me now, I told her, I said, call now and see, but you're at the end of the semester. They're in finals right now. But the summer semester is about to begin or go in the autumn.
Mhm. So, you mentioned domestic violence. If the parent who wants to be the guardian was the victim of that domestic violence, that doesn't matter, right?
No, that doesn't matter.
No, we're just talking about, if they have a criminal history or something like that.
By the
Talk.
way, let me just tell you this, since you mentioned it. I'm sorry for cutting you off, but let me just say it real
No.
fast. In the estates code, we have a disqualification, a whole chapter on disqualification. And there are specific things that will disqualify someone from serving as guardian. So and you mentioned it earlier, Michelle, if you owe the proposed ward, that's the legal term, money, you can't serve. It's adverse. If you've got violence in your history,
Mhm.
can't serve. And there's other things that will disqualify somebody from serving as guardian. If the parents have been divorced, and this is a personal pet peeve of mine. Sometimes the parents are divorced. Even if the parents are divorced and one parent is not active in the child's life, the other parent has to be served with citation. He has to be notified of the proceeding, even though the kid's over the age of 18. And if some parents like to relive their divorce through that special needs child, and divorce is in family court, it's a whole different set of laws. Guardianship, as I've said a few times, is probate law, but you can disqualify that person if he owes child support. So if daddy, or it could be mama who owed the child, so whichever parent owes back child support, they are disqualified from serving as guardian because they owed money that was for the benefit of the child. You can tell I get heated about this.
Yeah, yeah, that one fires you up, huh? I can
Yeah,
tell.
it sure does.
Yes,
I'm
yes.
looking at the chats here. Yeah, go ahead.
Yeah. Let's see. Here's another question in the chat box. Can the successor guardian live in another state? And then what happens? We've talked a little bit about statewide, and um, I get that, if there's nobody, then the probate court can help find somebody who could be the guardian. But there is a guardian, they're just in a different state. What would happen then?
That is allowed. And we have it, the parents that are retiring and moving to a different state, but daughter lives in a place here and it's great for her.
Yeah.
And there's a lot of great places. I don't want to name any to say that I'm favoring them, but there's some really good places. And it's become daughter's home or son's home. That's where they live and they like it and they have their social life there. Parents want to retire and move to North Carolina or Colorado or Oklahoma, wherever. Um, all the parents have to do is have what's called, and it has to be filed with the court, with a form called a designated resident agent. And that just means if the court has to notify them, they need someone in the borders of the state of Texas to notify. The Texas courts cannot jump to North Carolina and say, you're the guardian, you're in violation of a court requirement. They need somebody in the state of Texas to notify, to tell the parents. So it could be somebody else that lives here. If I have a case that's going on, I'll say, put me as the resident agent, because if you're in violation of court requirement, I need to know. If you're
Yeah.
guardian of the person, your big court requirement is to file that annual report with the court. And I think that's pretty standard in most of the states. You file an annual report. And the courts say, I've heard judges say, why do we need to get that every year? Because somebody can be under guardianship for 20, 30 years and a parent dies. How would the court know? Ward
That's
might
right.
die. The ward might die. How do we know? So,
Yeah. So these are the kinds of questions that you can expect if somebody knows what they're doing when you call to ask an attorney about guardianship. So these are the kinds of things that you start off with, right, Michelle?
oh yes, exactly. How old is your child? What's the disability? And I found, Michelle, I imagine you see this too. It's often hard for people to talk about the extent of the disability, or as
Mhm.
we were saying when we were preparing for this, you parents get used to living with it. You don't even realize how much more you're doing every day than other parents do or that you've done for your other kids. Uh,
That's true.
and they don't realize the extent of the your child's needs because you just take care of it. But when
Yeah, you just do it.
you
You
just do
kind of
it.
go, yeah, I think as parents, you kind of go into autopilot based on your situation, and your normal is not going to be normal at all for someone else.
Yeah, especially if you have to help your child take a bath. I mean, just how much more time you have to tag on to your day, help them eat, help them brush their teeth. It's a lot. So yes, I ask all those questions. If the child is older, let's say over the age of special ed, if they stayed in special ed till they're 21, 22, let's say the kid's 28, I always ask, did something happen that you need this at this time? Sometimes it's just we always looked into it, or something has happened and the parents find that they can't, and I can give you some more stories, but you already have your own nightmares. So, or your own fears. I don't need to pile them on, but something has happened and the parents can't take care of it because they're not the child, especially with the predators. I've had numerous cases over the years where there was clearly a predator situation and parents went to the police and they said, your daughter is a consenting adult. They went to the DA's office. DA said the same thing. We sympathize with you. It's clearly abuse, but your son is a consenting adult. We can't do anything about it. But if you're the guardian, then you can take care of it. So those are the kind of questions I ask. I always want to know about the finances. Do you have anything in your child's name? No. I said, are you sure? Did your parents set up an UGMA account, an UTMA account? 529s, by the way, are exempt from, you can still get your social security benefits, but that's another topic. But, and your child's not the owner of the 529. That's for educational purposes. You're the owner of the 529. Your child's a beneficiary. But just ask those kind of questions.
Yeah, those are so important. And thinking about, the special needs trust and things like that, yes, it is important if an individual with disabilities wants to get any SSI money or Medicaid or benefits like that. You cannot have money in their name more than $2,000. And that's where things like the ABLE account or the special needs trust come into play. You leave the money to the trust instead of to the individual, then it doesn't count against them anymore. So, yes, you should definitely have a special needs trust. Now, a question in the chat says if a trust is managing those distributions, does that company, that trust company who's managing it, need to have guardian of the estate?
No, in general, I'm gonna say no. It depends though, exactly how it is and what's funding the trust, the source of the money. But one of the purposes of having the trust is you keep it outside of the court system. But I have a
Mhm.
case right now. In fact, right now, the man is, I mean, I just got the signed contract today, just but the mail came in just before this webinar. Um, the man has a family trust. He's in his mid to late 50s. He lives in a facility, adult onset, not until he was about 27, 28, of severe mental illness. Just, it's really sad. It's just sad. And mother did all this great planning, but mother died and she left one IRA with him named as the direct beneficiary.
Oh
And
no.
his brother, who is wonderful, that takes care of him. The sister and brother really take care of this brother that lives in a facility with severe mental illness. Um, it was a direct inheritance. So we have to go through, he's under guardianship. We have to go through the court system.
Mhm.
The financial, I think it's with Morgan Stanley. It doesn't matter who it's with. It's the law. They cannot release the money. They cannot release the money. They can only release it to him, but he's under guardianship, so they can't release it to him. They need a court order. I said, we have to go through the court system. It has to go into a payback trust. Is there any way to get around that payback provision? Nope. It's his money. It's in.
No. And that's why we always tell people, please come to us early in the process and make sure, because if mom or dad passes away unexpectedly, and we never know what, I always like to joke and make light of it because nobody wants to talk about their death. And I'll say something like, if you happen to be crossing the street and get hit by an airplane, you never know what could happen. So it's
Or
so
brain
important.
aneurysm and you drop dead.
Yeah, yeah.
That was a call that came in this. I'm a probate attorney. I hear this, just stuff. You go, oh my gosh, he was only 37, literally.
Ah, and you never know when that's going to happen. So planning early is so important, not kicking the can down the road because you don't know when the road ends,
Right.
or hiding your head in the sand. That's not going to solve any problems. So get with someone like Michelle or someone like us, or
Both.
both. You do need both.
Both.
Yeah, because we handle the money side, and Michelle, you handle the legal side, and people need both of those areas covered.
Right.
Yeah, so if we don't live in the Houston area, maybe we live in a smaller community, where can we go for some legal aid that is low cost?
Um, I can't speak to smaller areas. I would see if there's a university in your area, but you would
Mhm.
need a university law school, but some of the small towns have it. Or if you're in a small town that's near a bigger cities, I would call the law school, see if there's a legal aid clinic. I think a lot of law schools have them. You can
Mhm.
also call the courts that do guardianship, ask if they can make a recommendation. Um,
The ARC actually is a good resource, the ARC of Texas, and that's a national organization. ARC is the Autism Resource Center, but they often don't necessarily care if the disability is just awesome, autism. But they offer, I believe, some guardianship aid in some circumstances.
yeah, I can't speak to that. I don't know, but they're always a good resource, and they have them. There's the Arc of Texas, and then they have the Arc of Greater Houston and the Arc of Fort Bend County and smaller areas as well.
Yes, yes. So speak with your financial advisor, other professionals in your life, doctors, uh, community, friends, and there's always, the support groups like on Facebook and things like the Awesome
Yes, that's a
Moms of
good idea.
Houston.
Yeah,
Those are good places
right.
to look as well, and to help you find an attorney or, a support team that's going to be able to help you. I think
I'm
we
just, no, go ahead.
I think we talked a little bit about this blood draw situation and the doctor's office, but what were you going to say?
Yes, we did talk about the blood draw. I was just looking at some of the questions in the chat box, which is, I'm looking, if you see me looking over to the side, that's what I'm not, I'm looking at these questions. We live in Uvalde. I don't know where there's legal aid. I'd call this biggest city near there. I'm not sure what the biggest city near Uvalde is, but go to the big city. You should have some aid there, I would hope. And then I think Michelle's idea of going on Facebook is probably one of the best things. Um, there was something forgiven. How does a parent remove guardianship if a child on the spectrum has become higher functioning over the years? I've done a number of these and the courts love to do them. Okay. The procedure is called a restoration and termination of the guardianship. It's a restoration because the person's rights are being restored. We see it often, as I mentioned earlier, with autism, where when they're 18, and all the other things are going on when they're 18, they're not stable, they need the guardianship, but as they age and they get stable, just hormones die down and whatever else, and they become independent. The courts love to do restorations. The other one where we really see it big time is with mental illness, because people are often very unstable in those early days of the onset of the mental illness. But when they're older, it calms down. They get stable if they're compliant. So a restoration, you have to have an attorney again, and it's really like getting the guardianship in reverse. You must have a doctor, just like in the guardianship, you have to have a doctor that fills out the specific form that all the courts require. We provide it to the doctor. And it's a functional analysis. What can the person do on his own independently? Handle a bank account, consent to medical treatment, psychiatric treatment, vote in a public election, drive a motor vehicle. There's a whole list of stuff. And you have to have a hearing, and if your child is under guardianship and wants to be restored, your child has to appear in court. It's required. And talk to the judge and say why they have to be restored. But you can do it. You're going to have an attorney ad litem again, and the courts love to do it because it means your child's doing well. He could be.
Yeah. I mean, that's great news.
One thing that I've done what we don't call a total restoration, but a modification. Looking at the time here, a modification of the guardianship. This is especially where mental illness is the diagnosis, the need for the guardianship, or one of them, because sometimes you have more than one diagnosis. Maybe you'll have autism and also some bipolar disorder. Not always, but sometimes. I've had people come to court. The adult child is a little older now. A little older could mean 27 or 48 or 53. It can be different ages, where we'll say we want to keep the guardianship for medical and psychiatric authority, but everything else will be restored. He can get his own bank account, he can drive, he can vote, he can do whatever he wants independently. And I've had people in court, it's really compelling when you hear it in court. In fact, I got goosebumps just thinking about some times we've been in court. It doesn't come up often, but when it comes up, if I'm having a psychotic episode, I want my parents to be able to come in, or my spouse or my older brother, whatever, to be able to come in and directly communicate with the hospital, with the doctors, and consent to my treatment. Because if I'm psychotic, I'm going to refuse everything. I usually when they're psychotic, they're like, no, don't touch me. I'm not taking meds, and on and on. And if the guardian can step in and override that.
That's really good. I've been kind of pushing the slides head in the background because I know that people can read and I know that they're listening to what we have to say. So I feel like we can keep answering questions if anybody wants to put more questions in the chat box. But as I mentioned at the beginning of this webinar, we at Consolidated Planning Group work on all kinds of informational webinars that we share with the community. We work with all kinds of families, and we're here to help you. This link, when you receive these slides later on today in your email, this link will take you to our upcoming webinars where you can check on topics that are coming up and pre-register. Of course, that will give you the link to the webinar right up front. You can put it on your calendar. You can get those reminders, and you can send in questions ahead of time. We do have questions that were sent in ahead of time, and we've been kind of sprinkling those in as we go. But I'm going to leave this slide up as we wrap up with any last questions people have so that you can schedule your free consultation with Consolidated Planning Group, and we can get in contact with you and discuss questions you might have on either side of this. And then if you need to talk to Michelle, we'll refer you over to her, or you can give her a call as well. So a question in the chat box says, what are the primary differences between SSI and SSDI? And will SSDI go away when the parents die? That's more of a question for my side of the equation. SSI, and we do complete webinars about this. If you go to our YouTube channel, which is through the link there, you're going to see a webinar called Government Benefits 101. And that's where we dig deep into the differences between SSI, SSDI, ABLE accounts, waiver programs, special needs trust, all of those kinds of things. But in a nutshell, SSI is supplemental security income. It's what your child should be able to qualify for on their own when they turn 18. Generally, they won't qualify before age 18 because at that point they look at the parents' income and assets, and you probably have too much or make too much. But when the child turns 18 and becomes an adult, they only look at their income and assets, and that can be kind of monitored to make sure that they fit the criteria. That is a monthly payment. Right now, it's the maximum is $994 a month, and it comes with Medicaid. The SSDI is a term used for a program that comes later in life when the parents turn on their Social Security, whether it be because they turned on their retirement benefits, became disabled, or passed away. And then the child gets a benefit based off the parents' work history. They keep their Medicaid, but they lose SSI. But after they're on this SSDI benefit for 2 years, they're going to get Medicare as well as Medicaid and be dual eligible. So please give me a call and set up an appointment with us. We'll walk you through those and help you with all of that. Did you see that last question on there, Michelle? Can an individual or parent court-appointed attorney? Wait a minute.
Yeah, I'm trying to figure out that question. I'm trying to figure out what the question is.
Can the parent interview a court-appointed attorney in advance? I think that's what they're saying. So that they know who this court is going to appoint as an attorney for their child.
No, it did, and I can't. We're not allowed to request an attorney ad litem. The judge, each judge, the judge has to appoint the attorney ad litem, and the judges have what they call a wheel. They have to move it around, and so they don't keep appointing the same person. The courts do try to match the attorney ad litem with the case. Maybe you need a Spanish speaker. I see that's one of the questions. What can you do with Spanish? So if there's a Spanish speaker or Vietnamese speaker, whatever, they'll try to match that. If they know somebody has a lot of experience with special needs kids, they might try to match that. But the judge appoints the attorney. You cannot interview them in advance. The attorney ad litem will call you. It's called attorney ad litem, which means for these proceedings only. I serve as attorney ad litem. We have to have a special certification to do it. So it's not out of the entire pool of licensed attorneys in your area. It's only the attorneys that want to do this kind of work. So usually it's somebody that's okay because they want to do this work.
And what about court, when the court has to appoint the guardian, can that guardian be checked out by the parents?
Yeah, I mean, there has to be well, yes, but if the judge is going to appoint we call it a third party guardian, that means there's something going on with the parents that the parents can't be appointed. So unless it's something personal, like I have end stage pancreatic cancer and I'm under treatment and half the time I can't get out of bed, unless it's something like that, I don't know how much
yeah, I mean, if your child is, I mean, maybe they're just planning ahead for the future because they know that they don't have any other family, and it will have to be a court appointed or court chosen guardian. So they're thinking, can we pick it ahead of time before we die?
But you don't know who it's going to be. Well, you could, I guess, if you know, because I do have people that call and say, I know somebody that serves as guardian. Great. Let that person, when the time comes, that person will need an attorney and files an app, or if it is an attorney, they can do their own court documents, make an application for guardianship, and in its state, although I'm not family, this is the term we use in the court is I'm an interested party because I've known this family, we're personal friends. I am an attorney licensed in the state of Texas or Ohio or wherever you are. I know the family personally. I've known this child since she was 3 years old. We have a good working relationship. I am willing to serve in that capacity. I'm qualified to serve, something like that. And yeah, the judges will try to do that. The judges will try to honor what the parents want. It's pretty unusual circumstances,
Yeah, yeah, I would bet.
but the
Well,
parents,
thank you.
yeah. Oh no.
Was there one more bit of information you
Yeah,
wanted
and
to
I see we're
share?
at time. No, I was going to say the parents, and when they're talking to you, they should be disclosing this information to you. The parents should, in their wills, when they're doing
Yes.
their wills, their special needs legal planning, they should say, I designate my daughter, I designate my niece, I designate whoever it is, my best friend, to serve as successor guardian. They
Yes,
still have to
yes.
go through the court system.
Yeah, there's a lot of planning to be done. And like I said, we can help you figure out between the two Michelles, the two different companies, the two sides of the coin to help you with your special needs planning. We can help put together a roadmap for you for your specific situation. We can also talk to you about what needs to happen now and what can wait. So please set up your free consultation with us. Michelle, do you also offer a free consult?
I will speak to somebody and not charge for up to 30 minutes, but if they need more than 30 minutes, I charge a consultation fee. I've found that
Okay.
people just want to talk and talk and talk. I can't sit on the phone all day. I have to get with my work.
Yeah. Yes, yes. I think a lot more companies are heading in that direction. So feel free to reach out to us. I hope you all have a great week and you've gotten some helpful information here today. Thank you so much, Michelle, for all of this. And
Thank you,
I'll
Michelle.
talk to you all soon. Thank
Thank you.
you.
Thank you.
Bye-bye.